Last week, a district court in Goa held Tarun Tejpal not guilty of sexual assault. This complaint was filed against him back in 2013 by one of his former employees at the Tehelka magazine. The district court judge's reasons for not holding Tejpal guilty are three. First, that there are inconsistencies in the versions of the complainant's account of what happened to different people. Second, that the police had made error by not properly investigating some key witnesses and pieces of evidence. So it is possible to afford Tejpal reasonable doubt. Third, the court held that the complainant's conduct before, during and after the assault do not make it possible to believe that she is a victim of rape. The prosecution, that is the state of Goa, has decided to appeal this judgment before the Bombay High Court. Leaving the first and second reasoning to be examined by the High Court on appeal, in this video let's talk about the court's third reason and why it has brought heavy criticism for this judgment. In how it's written, this judgment seems to break from the standard form of writing judgments. Normally, a judgment would discuss the arguments made by both sides of a criminal case. However, this judgment devotes a majority of its 500 pages to discussing the full examination of the complainant and her conduct after the alleged assault. This conduct is discussed even when it seems to bear no real relation to the contents of her complaint. In striking contrast, the accused and his conduct are nearly missing from the text of the judgment. So what does the law have to say about such a handling of rape trials by a court? The Supreme Court has time and again held that courts should not treat the statements made by complainants in a rape trial in the same way that they would treat the statements of an accomplice to a crime. Critics of this judgment say that the hyperfocus on the complainant's conduct make this look like she was on trial and not the accused. It is essential to note that in a rape trial, the main issue is meant to be the conduct of the accused person. What, you might ask, is the harm in making a rape trial all about the conduct of the complainant? First, this may re-traumatize the complainant who is now virtually put on trial herself. Second, it may create the idea that certain behavior is normal for rape victims. Anyone who doesn't behave like this can't be a rape victim. Third, it may create the idea that some behavior is unsuitable for good women. Women who behave in such unsuitable ways must necessarily have invited the sexual act and so should not be believed when they say they've been raped. This judgment replicates some of these harms. The victim is painted as lying because she behaved in a manner unlike normal rape victims. The court uses a bizarre set of reasons to arrive at this conclusion. Some of them are, first, that the complainant was educated in rape law, was a feminist, and had consulted other feminist lawyers and activists. This was considered as making her someone who would doctor her accounts to win herself a favorable judgment. 2. Right after the assault, the victim was at a work event of which she was one of the organizers. She was photographed smiling, drinking, and socializing at this event. For the court, this was not how a rape victim would behave. 3. She chose to share that she had been assaulted with some male colleagues before doing so with some female colleagues who she was allegedly closer to. 4. At this work event was present a person who the complainant knew to be a rape survivor and an advocate for other survivors. She did not confide in this person. For the court, it was abnormal that one rape victim would not confide in another rape victim, and so the complainant was suspicious. The court also goes into graphic details of the past sexual relations of the complainant. They also discuss instances of a flirtation with co-workers and friends. In rape law, courts are not allowed to entertain such questioning because it creates the idea that a promiscuous woman must have consented to the alleged sexual act. To make these arguments, the defense counsel violates the complainant's privacy by obtaining a carbon copy of her phone data and by placing on public record her private conversations, even when these conversations don't seem to have much to do with the contents of her complaint. The complainant's attempts to protect her privacy are interpreted by the court as her having something to hide. Her legal right to anonymity is also disregarded. The judgment is littered with careless mentions of her email ID, her family members' names, and other personal identifying details. All this information was available to the public until the Bombay High Court ordered that this information be redacted. Tejpal, the accused, has suggested that this case is a political vendetta against him, headed by the BJP-led state government of Goa. This suggestion has gained ground because of the past work of Tehelka magazine that has been critical of the BJP. Such a suggestion raises some questions though. Why would the BJP collude with the complainant in such a political vendetta when she has also been part of such work critical of the BJP at Tehelka? Yes, the police investigation and the prosecution's trial is led by the state government. And so, one must be careful that party politics do not affect the police investigation or the conduct of the trial. However, we must remember that in a criminal investigation, the complainant and the prosecution are not one and the same. So, the complainant and the hurt caused to her cannot be dismissed because she is not the state government.